Next from Springfield, we head to a committee hearing on Governor Rauner's proposed pension plan and hear from representatives of the Office of the Governor and reps from the Illinois Teachers Federation and AFSCME, among others. This runs about 40 minutes.
I'd like to thank Chairwoman Neckrits and the entire committee for having us here today to discuss the crushing pension liability facing all units of government in Illinois, and also the governor's holistic approach at finding a solution to that pension problem. As we are all aware, the 5 state-funded pension systems in Illinois, the Teachers Retirement System, State Employees Retirement System, State Universities Retirement System, the General Assembly Retirement System, and the Judges Retirement System, have over $100 billion in unfunded pension liability. But unfortunately, the pension problem in Illinois does not end with the state systems. The other pension funds throughout the state that provide pension benefits for all remaining public employees have an additional $50 billion in unfunded liability. So whether it's Joliet or Jacksonville, every layer of government and every taxpayer in Illinois is scrambling to pay off an ever-growing amount of pension liability that is suffocating government budgets and stifling economic growth. With the pension problem affecting every aspect of government in Illinois, Governor Rauner recently released a draft of a holistic, all-encompassing constitutional approach to reforming the public pension systems in our state. With that, I will give you a quick walkthrough of the draft. The draft applies the consideration model to the state of Illinois pension plans, the Chicago Teachers Pension Fund, the downstate public safety pension plans. It also contains Mayor Emanuel's pension bill, Senate Bill 777, that was passed by both chambers of the General Assembly in May, and adds to that downstate public safety funding relief while incorporating a new Tier 3 hybrid pension plan for newly hired public safety employees that allows for greater local control of pension benefits. The draft also provides Cook County a choice of pension reforms. Their bill, they introduced Senate Bill 843, which passed out of this committee, or a consideration model, and it additionally grants local governments the right to restructure their finances. I will go a little more in depth on the consideration approaches that are used in this bill, and then we'll hand it over to Dennis, who will discuss the legal theory and collective bargaining changes. For the state employees retirement system, the draft creates a new baseline of benefits for active employees and then creates several incentive options where if an employee wanted to receive additional benefits, they could move into the Tier 2 pension package for all future service. The new baseline includes a guarantee for 5 years that wages will not decrease, vacation time of 2 weeks if you have under 15 years of service and 3 weeks if you're over 15 years of service, adjusted seniority rights, and overtime pay will kick in at the federal standard of 40 hours a week. After the creation of the new baseline, there are incentive packages that will be offered to state employees if they are willing to transfer into the Tier 2 pension benefit plan for future service. A salary package that offers a transition bonus of $2,000 and a one-time $3,000 salary increase, a vacation package that offers the same $2,000 transition bonus and a one-time $2,000 salary increase, plus 2 additional weeks of vacation, overtime package which allows 2 additional weeks of vacation, priority rights for scheduled vacation, overtime, and bumping, and also the $2,000 transition bonus. For the other pension systems where the consideration approach is employed, which is TRS, SURS, GARS, and CTPF, and the downstate police and fire pension plans, Tier 1 employees must choose between keeping their Tier 1 COLA or having future salary increases count towards their pension benefits. With that, I'll hand it over to Dennis, who will walk you through the legal approaches and collective bargaining changes, and look forward to answering any questions you might have.
Thanks, Mike. Madam Chair, members of the committee, I too am delighted to be here to discuss the governor's holistic approach to the state's numerous pension problems. Before we get to the most important part of this hearing, which is your questions, let me briefly sketch out the legal framework that gives us a path forward. I could try to do this using Tour de France language, but I'm going to stick to the prepared remarks. I'm not sure I can deviate easily from that.
It's safer for you that way, Dennis.
That's right. So recall that in the most recent decision dealing with pensions, our Supreme Court has explicitly mentioned the contractual framework as a constitutionally permissible way of structuring pension reform. So the question is, well, what is that framework? There are 3 parts to it. They flow right out of the language of the pension clause that says membership in the pension system is an enforceable contractual relationship. First is consideration. There's 2 parties to a contract, and they can modify it through a voluntary exchange of promises. We all know that. We all agree with that. Think about refinancing your home loan. You give the bank some money up front in exchange for a more attractive interest rate. There's 2 parties coming together and making a mutual exchange of promises, right? It must be completely voluntary, so that's the important part. All agree that consideration cannot be coerced. Each side must have a true choice and of course, an ability to walk away from the negotiation with what they had before they walked into it. If you don't want to refinance your home loan, you don't have to. That's consideration. The second part, undisputed, is that the pension clause does not protect what I will call inputs into the pension formula. What are those? Wages, hours, other variables that fit into the formula for calculating your pension benefit. So the pension clause protects the pension benefit against the impairment. It does not protect the inputs. It does not protect your salary. It does not protect the how many hours you work in a particular year to earn service towards your pension benefit at the end of the day. The case law is clear here that the inputs themselves do not trigger the pension clause analysis, and we have our appellate courts who've clearly said, and the one quote in particular comes to mind, a reduction in work hours or in salary itself is not a diminution of benefits within the meaning of the pension clause. And courts of other states agree. As you know, our pension clause was borrowed from New York Constitution, and New York courts have said the same thing. They've said that salaries may be changed in a way that affects pension benefits. Such changes do not trigger the pension clause analysis. And last, the critical step is you can craft the most beautiful bargain. It can be the best bargain for the state employees, and it doesn't do you any good if you cannot actually approach the employees one-on-one and negotiate with them the bargain that you've put together. Such one-on-one negotiations are not currently permitted. You cannot approach employees with that bargain. Collective bargaining laws in Illinois prohibit the state from negotiating with employees individually over a host of subjects: pensions, wages, work schedule, overtime, holidays. So these laws, the collective bargaining laws, must be modified to allow us to approach employees and offer them true consideration, true choice. So those are the three elements providing the constitutional foundation for the governor's comprehensive pension proposal: the consideration part, framework, things that do not trigger the pension clause analysis, and given the state the ability to negotiate with employees one-on-one without having to go through the collective bargaining representatives and actually give the employees the true choice. If you put it all together, as Mike summarized, our plan offers employees in Tier 1 plans a true choice of keeping their current pension plan or moving into a new plan going forward in exchange for raises, vacation, and other attractive benefits. Now, employees do not have to take that choice. They can stay in the current pension plan if they choose to. So doing that, putting it all together, allows us, I'd say all of us, to work with state employees and solve what's really the biggest problem facing the taxpayers, the $100+ billion budget, not budget hole, the pension problem that the state faces. So with that brief background, Madam Chair, we welcome your questions. Thank you.
Thank you very much. I'd like to add Representative Poe to the roll, and I have a letter from Speaker Madigan replacing Representative Ammons with Representative Harris, and indeed, Representative Harris is here. Questions from members? Representative Harris.
So this is a question for Mr. Morosco, and I'm going to ask it as a lay person because I'm not a lawyer, so bear with me if my formulation is not too good on this.
I'll try to answer as a lay person too.
Okay. So you said the third tenet of the governor's proposal is to allow the state government to bargain one-on-one with each employee, as opposed to bargaining collectively. Is that a fair summary?
Correct. To give them the true choice that you've tailored to each person, you approach them individually. To do that, you need to take certain subjects out of collective bargaining. That's right.
I mean, and to me, that just, how do you answer the criticism then that, the power of the state government, in all of its majesty, going to each individual employee has tremendous leverage against an individual that the individual cannot, really adequately respond to, and collective bargaining serves a purpose in allowing people with like interests to leverage their ability to negotiate, with the state with, a capital S.
So if you, that's a good question, Representative. If you look at the bill, all the different provisions that provide for what kind of package has to be put together before it's presented to the employee, there's a lot of checks built into it. So there's all sorts of explanatory materials that have to go in. There's video materials. There's an opportunity for each employee to consult with their chosen counsel over that question. So it very much addresses the issue of making sure that the employee understands what the choice is, understands what they're taking up, what they're giving up, and what the exchange actually represents.
So it would be your position then that, some agent of the state government would go around to, each employee and go, to Rob Martwick, Rob, do you want to give up a week of vacation and get extra health care? Or, Rob, do you want to give up a week of vacation and you can stay until when? Everyone's going to have to make that decision individually, and if they choose to go out and find someone to advise them, then it's up to them to find somebody who understands the impact of what they're saying?
Right, I'm not sure that Rob is going to be tapped on the shoulder the way you just did, because that creates something much more sinister, perhaps. I think there may be a mailing, there may be a central management services agency sending Rob a letter and advising Rob of what the rights are, and then Rob has a choice to find counsel for that, much like any number of other decisions that Rob makes in his day-to-day life that are complex but important.
And that have consequences. Are these revocable or irrevocable decisions?
The decision to transition, for example, into a Tier 2 structure going forward is an irrevocable decision because the person is making an exchange. There are consequences to that exchange.
Yeah, but those consequences once made, a person, I just remember going through with my parents the sign up for their Medicare program. And they had, 5 or 6 choices, and sitting there trying to, go through these reams of paper and understand what the consequence of those choices was, it was very daunting. And, I remember my dad made a wrong choice the first year, but once they found out that this really negatively impacted their lives, when, the enrollment came around the next year, they were able to say, well, we're not going to make that mistake again. Here you're asking, tens of thousands of people who are not really necessarily experts in pension law or benefit to make decisions that for the rest of their lives and for their widows or families or survivors' lives are going to have profound changes. And that concept worries me.
If you want me to respond to that, Representative, a couple of thoughts. It is an important problem that we have, and so the choice, I wish it were very simple. This is not a simple problem. So that's the first point. And the second point is we can definitely work together to come up with language that should go into the notices to employees and to structure the provisions of this bill that go to the notice question to make sure that folks understand the first time they make that decision what the consequences are.
And so in your second point, you said that, and you used the example of refinancing your home loan, and you said, at any time, you have the power to walk away with what you came in with. But if I understand what you're asking us to do in this legislation, right now the employees have collective bargaining. They have unions who use their collective bargaining power to negotiate about getting advantageous wages, salaries, and benefits. And if this bill passes, then the employees will not have that anymore, and that also is irrevocable.
Right, I'm not sure a way around it to make sure that the consideration framework will work to fix the state's pension problem. So if you accept that framework, then you have to work through the implications of where that leads you, and one of the things you have to do is figure out a way to approach employees individually.
So it's your belief that you cannot use a consideration framework unless each individual employee without collective bargaining makes their own employment decision with the state?
It's hard to think of a true consideration model in the collective bargaining context.
Okay, that's helpful. I don't want to take up all the time. Thank you.
Thank you. So we have about, my estimation, about 40 minutes left, and I've got 3 members seeking to ask questions. Is anybody else wanting to ask questions? So I'm going to allocate, I'll let you go about 8 minutes or so. Is that okay? And then, okay, Representative Morrison.
Thank you, Madam Chair, and thank you, gentlemen, for the testimony this morning. I just would want the committee to reflect upon how the testimony began. It's easy for us to just kind of gloss over the numbers, but we're talking about over $100 billion in unfunded liability. Virtually everyone, as we've discussed this for years, this is unsustainable. It's not sustainable. It's not sustainable for a state to approach 25% of its annual budget going to pensions. It's not healthy. It's not sustainable. And and furthermore, we have issues at the local level too. And so I appreciate the notion of consideration. As I have talked to individual constituents who work in the public sector, they will share with me via email or phone call or face-to-face conversation, Representative Morrison, I would be willing to do X, or I would be willing to do Y. I would be willing to do Z. I think the fact that if you give individuals options, choices, then you're empowering the employees to make decisions. They all know, most of them know, I would say, that the consequences of not addressing this, solving it, means cuts to current workforce, cuts to needed spending. They're aware of the consequences of that, and they want to be part of the solution. I think the best way to do it is on an individual basis. In those conversations, I don't hear a single person say, my union would be willing to do this, that, or the other thing. It's always in the context of I would be willing, I would be willing, I would be willing. And so I appreciate this, and just look forward to further questions, but I thought that having that insight is helpful to the conversation. Thank you.
Thank you, Representative. Representative Zaleski.
I've tried to take 8 minutes. I'll be as quick as I can, but I do have some real questions. First of all, it seems like the plan is designed to induce people into going to Tier 2. Is that a fair representation of I mean, I don't want to mischaracterize anything, but I want to know if I can get as clear an answer on that as I possibly can.
Sure. So for the state employees retirement system, the incentive packages are put in place to try to incentivize employees to move to Tier 2 going forward for future service. For the other systems, we follow a consideration model that we've seen before coming out of the Senate, where you can choose between your pensionable salary increases or your COLA.
So that, to me, Mike, seems like it's based on the court's ruling, which was a footnote that said that you can collectively go after consideration going forward, but you can't alter existing benefits. And what concerns me, after having read that opinion and the governor's proposal, is that I think a lot of people, frankly, might misunderstand that footnote. And I think the court made it very clear that we're not necessarily able to make employees, taking what Greg said on a micro level, but more on a macro level, I don't know that the court would allow us to do what it is the governor's proposing we do, which is induce people to try to go into what is arguably a much worse benefit package by tinkering with their vacation days or their overtime pay. So I guess my question is, when the bill was drafted, was it based on that footnote, and how are you able to reconcile that footnote with the rest of the opinion?
So that's a good question, Representative. You kept saying inducement. If you pardon me, I'll use incentive, something other than inducement necessarily. So going back to the three things that I've outlined, the critical one is the second one, which is we can change salary, we can change a whole number of inputs into the pension formula. You would, I hope, agree with me that the opinion does not change that. We can still choose what we pay our employees, assuming we don't have the collective bargaining restrictions, of course. If you can choose what you pay your employees, then you can craft various incentive packages to incentivize the employees to transition into a different pension tier going forward. What happens in that choice that the employee makes is they have a status quo option. They can stay with their benefit. So if they decide to take on Tier 2 structure going forward, and earn Tier 2 benefits going forward. Remember, they're going to have the Tier 1 benefit for however many years of service they've earned through the date of the choice. So because of that voluntary exchange, we don't think there's any problem that the Supreme Court flagged in that footnote, and the rest of the opinion, it just was not there. The footnote is critical, but it doesn't change. It sort of confirms what you would have expected without that opinion, which is, as a voluntary choice, what can possibly be the issue?
I think the rebuttal to that, if to respectfully, is, if Senate 1 had a pensionable salary cap in it, and it basically said at a certain point, your salary isn't above, if it rises above X amount, you don't get that, you don't get a pension benefit based on that. And the court had it well within their rights to have severed off that benefit change and give us the opportunity to deal with that, and they chose not to. So they took a holistic, they sort of took a wholesale approach there that that's not the, that wasn't an option available to the General Assembly. That being said, I certainly appreciate the thought. On Tier 2.
Would you take the rebuttal to the rebuttal, or?
Well, I don't want to lose my time, sir. And you seem well-versed in this. I'm happy. I'd like to talk more about this in future opportunities. But on Tier 2, we've struggled as a committee with Tier 2 now for the last two years. And I think it's fair to say members of this committee have genuine concerns that when we created Tier 2, it wasn't designed in a way that to be a true benefit that people can rely upon, and it needs a lot of work. And again, I'm appreciative of the governor's proposal. And the atmosphere down here is really toxic right now, and this is not meant to be an attack. It'll be perceived as an attack. It's not meant to be an attack, but it's evidenced in the fact that Tier 2 is lacking when Mr. Smith chose to be in Tier 2, Tony Smith, and the board felt the need to supplement his salary. That's not meant to be an attack on Tony Smith. I've met him. I think he's going to do excellent work for the Board of Education. But it's evidenced in his hiring and the reporting that was done on his benefit package that Tier 2 wasn't alone sufficient enough to cover what he would consider to be a reasonable retirement package. So I'm wondering, is there any consideration the governor's office has made to buttressing Tier 2 or supplementing Tier 2 or making it a more desirable benefit package so that we can address the concerns many of us have about that particular tier?
Eric, I'm sorry. Again, I'm John Cameron. I'm the political director for AFSCME Council 31, and thank you for the opportunity to testify on the governor's newly released pension proposal. I mean, as you've heard, the governor is presenting this proposal as a path to resolving the state's multiple pension debt funding crises, not just the state, but those at the local government level, those dealing with city and county and school districts, all of which our union represents individuals in, as well as my colleagues here who represent many more folks in the educational world. And our collective belief is that far from being a pathway to solving this problem, this is yet another dead end. That one is both manifestly unconstitutional and an utter non-starter when it comes to resolving these serious crises, which we must address. As we have heard, the pension benefit changes that are being proposed are predicated on the wholesale abrogation of collective bargaining rights for public employees in state and local government. Public employee collective bargaining has been the law of the land for 30 years in this state. It has served the state well. It has assured both labor peace and the continuation and the provision of public services in many different areas of government in a continuous way with the minimum of disruption and with the maximum, in our belief, of fairness to public employees. So if the governor wishes to substantially diminish or abolish the Illinois Public Labor Relations Act or the Illinois Education Labor Relations Act, he can put that in a piece of legislation. He can bring it before the legislature. I suspect it would not pass out of this committee or any other committee of the House, and I am certain it would not pass on the House floor or get the approval of the state Senate. So to us, that is a non-starter direction to go. On top of that, of course, there's the constitutionality. And with our reading of what is being proposed, this simply cannot pass muster in light of the Supreme Court's decision on SB 1. The governor has offered is really a series of drastic benefit diminishments, claiming they are based on this consideration model. But if you read the court decision, I think it's quite clear what it says about consideration. It says that additional benefits may be offered or may require additional contributions in consideration if they are offered. In other words, something more can be required for something more that is provided. What the governor's bill and what the framework he's laid out is provide something less or something less. And I think both Representative Drury and Representative Mark have hit on these points already, and we would emphasize that this is not consideration. This is a coercive choice, which we believe is a diminishment of benefits and, in light of the court's opinion, decision, clearly unconstitutional. So rather than pursuing this constitutional dead end from our perspective, we believe lawmakers should heed the advice of Justice Burke that she gave yesterday and recommend that we read the decision in its entirety and follow the advice that is there. As it makes clear, lawmakers in the past are responsible for the pension debt crises that we have by diverting and underfunding their pension obligations, and they have it in their power to raise the funds necessary to fully fund those going forward, which is their constitutional obligation. So in sum, we'd say we'd stand ready to support the work of that committee on that pathway and recommend that we oppose any further consideration of what the governor has laid out today. Thank you.
Good morning. I'm Will Levitt with the Illinois Education Association. There are just really two things that I want to mention today. The first, speaking specifically to the consideration model for educators, it's a choice. You keep your cost of living adjustment and forego any future salary increases from being calculated into your annuity, or you choose your future salary to be pensionable, and you also diminish your COLA to become, instead of a 3% compounded COLA, to a COLA that's half a CPI, 3%, whichever is less, and it's simple. So this is not necessarily a choice. It is a coerced choice, in our opinion, to be made by educators who do not receive Social Security. This, as it was characterized earlier, the true choice is not, as stated by the governor's office, is not as described. This is more of a choice of how do you want to cut your pension benefits. Not just your pension benefits, your constitutionally pension benefits. The pension code says that the calculation of a TRS Tier 1 annuity shall be the average of the 4 highest years of service and a member's 4 highest consecutive years of service in the last 10 years of service. This proposal clearly would change that calculation, which has again been unanimously affirmed by the Illinois Supreme Court as recently as May. Secondly, the Tier 2 escalator is not really a COLA. The Tier 1 COLA, as it currently exists, as 3% compounded COLA, doesn't even keep up with inflation, as indicated with Social Security. Since 1975, the Social Security escalator has averaged 3.98%. The member's Tier 1 COLA is 3% compounded. So it's still, when compared to Social Security, the Tier 1 COLA does not even keep pace with inflation. Now, back on the Tier 2 COLA. The Tier 2 COLA has been for years described as inadequate. TRS has consistently raised concerns about whether this will force the system's coordination with Social Security. Because the question is, does the Tier 2 benefit stay at, if not greater than, the benefit offered to those members if they were coordinated with Social Security? Representative Neckritz has sponsored House Resolution 358, which would seek clarification whether the Tier 2 benefit package will stay within the Social Security Administration's definition of safe harbor. We support that resolution. When Tier 2 was passed, the IEA, along with the other members of labor groups or representatives of labor groups here at the table, warned the General Assembly about recruitment issues, whether it's within the state employee ranks or those at the universities or in the educational profession. Just last week, Diane Ratto of the Chicago Tribune reported that the State Board of Education will grant an additional stipend worth tens of thousands of dollars to the new superintendent of the Illinois State Board of Education. This was, as stated by a spokesman for the State Board of Education, to, quote, structure the contract so that the payment to Dr. Smith would be the same amount as if he were a Tier 1 employee, end quote. This stipend obviously shows that Tier 2 is impacting recruitment. This proposal has many issues. It would be helpful if people would reread the recent court decision. I often reread it myself. So that any ideas going before the legislature would be based on reality and not just the political whims of the day. My friend from the governor's office said that this is a path forward. This proposal is a path forward. I would say that the Illinois Supreme Court would clearly say otherwise. Thank you.
Nick Yelverton, Illinois Federation of Teachers, representing 103,000 members, including state employees and educational support personnel throughout the state. Thank you very much for the opportunity to testify before you today, and I just have some brief additional comments to my colleagues. First of all, clearly this piece of legislation presents what I would deem a choice of damned if you do and damned if you don't. It is no choice at all. It does not provide a consideration. It simply says to you, which way do you want to cut yourself? You want to cut your finger or do you want to cut your toe? And frankly, we believe that is no choice at all, and it's simply a forced choice upon someone, is coercive and does not stand the test of legal situations, so to speak. This is frankly a debt problem. And by trying to lower benefits in order to solve a debt problem is something that the Supreme Court has said is not viable. It's like reaching for an apple when what you really need is an orange. And unfortunately, this piece of legislation further reflects this idea that benefits can be reduced to the point where your contributions become affordable and you are thus able to get out of the debt problem. My final point that I'd like to talk about is Tier 2. Tier 2 compliance is something that is certainly in the question of Illinois. Several resolutions, including the Chairman's House Resolution 358 and Senator Biss's Senate Resolution 317, were both proposed this session. Senate Resolution 317 was approved by the Senate, and I might add, was opposed by the administration. We find that curious, since we would think that since they're trying to push people into Tier 2, that they would want to find out whether or not Tier 2 is actually compliant with Social Security. If Tier 2 is not compliant with Social Security, the consequences are dire, and something that has never been approached in this country before. To mandate Social Security payments upon school districts would have a devastating effect on property taxes, and also have a devastating effect on individuals who are in the middle of retirement decisions and moving towards retirement age. I will leave you with a couple of quotes, especially regarding the article that was referenced earlier. One of my members, Steve Grossman, who sits on the Teachers Recruitment and Retention Task Force, I think sums it up nicely. Tier 2 educators feel like they've been treated as second-class citizens. And to us, the idea that the state school superintendent will receive what is admittedly from the State Board of Education a stipend in order to make up the difference between what he quote-unquote deserves or needs between Tier 2 and Tier 1, and to treat teachers differently and in fact to present them a choice which is mutually detrimental is something that our educators take to heart and find very disheartening. Again, thank you very much for the opportunity to testify, and be more happy to answer any questions.
Are there any questions from members? Representative Morrison.
Thank you, Madam Chair. I would guess, thank you for your testimony, and I figured that you'd be vigorously opposed, but I would just ask, would any of you maintain that individuals within your unions would have specific needs or desires that they would like to address on an individual basis? In other words, are there individuals within your unions that would like to do something differently than the rest of the group?
Well, considering that between the three of us, we represent close to 300,000 Illinoisans and their families, in addition to that, I'm sure there's a variety of individual options or desires among them. However, as you know, and has been, I think as Representative Harris laid out from the beginning, you know, the premise of collective bargaining is the ability to maximize the individual's best interests by working together with similar individuals to achieve the best options. Now, when I choose to retire is an individual decision, as it is for every teacher and for every state employee and for every local government employee. What my options are depends on, you know, what career option, what my, you know, immediate personal goals or dreams or plans are, what my family needs are, what my health needs are. There's a lot of individual choices already built into the systems already, and clearly I'm sure my colleagues from local government who are behind us could talk about that as well. So yeah, there's plenty of individual choice, but the premise of this bill is not to maximize individual choice. It's to maximize the power of state government to coerce people into an inferior retirement system, which the Supreme Court says you cannot do. So at this point, I think, you know, that is this committee has spent years dealing with this complicated problem, and the chairman has spent many thankless hours doing so, and which we're all fully aware of. But to spend another, you know, 6 months going down this path, to spend another year talking about this, seems to be, as I said initially, a total constitutional dead end in the wrong direction to really grapple with the problem, which, as you know, the Supreme Court said, Justice Burke said yesterday, is in the decision. You know, we have to grapple with the hard choices. You're absolutely correct. It's a huge problem we have to deal with, but the problem involves, you know, raising the required revenue to meet the debt problem that your colleagues in the past have created for the state of Illinois.
So I would say, so revenue, so basically your position is we have to raise taxes to solve the pension issue.
Well, we certainly have to raise the revenue. Now, I heard on the House floor last week, Representative Franks talking about a variety of measures that are not tax increases, but rather closing tax loopholes for special interests, which I believe he estimated could raise as much as $2 billion annually. Certainly, that's, you know, that may be an exaggeration, that may be an overestimate, but certainly it's something worth pursuing. There are options to raise revenue without raising tax rates. However, I think the court was also clear on that decision. This legislature, or your predecessors, essentially made a, you know, self-imposed decision to reduce revenue to the state when you did not extend the income taxes, and that is exacerbated the problem that you're faced with. So I think the legislature says, you know, has to grapple with that. I think the governor's been clear that he said he's open to raising revenue. I think the Civic Federation has said you must raise revenue. I don't think that that's a, you know, that's not really a question. The question is how are we going to do it, and how can we get on to the serious business of fixing this problem?
If we change the tax code by either raising rates in one existing area or adding a new category of tax, can we guarantee increases in revenue this year and the next 10 years, 20 years, 30 years? Is there going to be a guaranteed revenue increase if we adjust the tax code?
I'm not sure what you're asking. I mean,
my question is, we don't know what the future is. We don't know what the future is. So adjusting the tax code will not guarantee increases in revenue over the mid or long term. And since that is an unknown, we cannot guarantee, we meaning the state or individual units of government, cannot guarantee employment levels, cannot guarantee pay increases. All of those are unknown factors. And so I guess my message that I'd like to pass on to you and your members is we can't guarantee those things. The constitutional language is pension benefits cannot be diminished or impaired, but we can't guarantee employment. We can't guarantee pay increases. All these things are huge questions. And in my earlier question, or more like comment to the governor's staff, I said, you know, it's unhealthy for the state to be spending almost 25%. I need to amend that. It's not just unhealthy, it is a crisis. It is unprecedented that a state would spend so much towards current pension payments. It is a crisis, and so we do need to move in a different direction. really all I have to say at this point. But I appreciate you providing your perspective, but I want to just push back a little bit and just say that individuals within your unions, because I've talked to them, I've had those conversations, and they've said, you know, I'd be willing to retire at a later age, or I would be willing to pay more I would be willing to give up part of my sick pay as part of my pension calculation. Individuals want to make those choices, and I think we need to empower them to make those choices, because they do want to be part of the solution. That's what they almost always say. I want to be part of the solution. I don't want to see the state in this position. It's not healthy. And we are, you know, Will, you made the comment that we may be having difficulty recruiting people. At the individual level, at the school district level, when there are openings at school districts, there's no lack of resumes being submitted. There's no lack of qualified candidates applying for those positions. So I don't think that recruitment is a possibility. However, on the tax side, on raising of revenue, whether rates or adding new categories of taxes, nothing in the state constitution forces individuals or businesses to stay in this state, to provide revenue. That's really where you get revenue, is having a growing economy, in having a vibrant addition to your population base, to your tax base. That's where you get additional revenue. And if you don't do that, even if you raise rates, you're going to, over time, have a reduction in net revenue. So anyway, I appreciate, and we can have further conversations after committee.